Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
The CHIPS Act was and still is big news in the U.S. We've talked about the CHIPS Act and some of the growing pains involved with it in other podcast episodes. These are being compounded recently in the U.S. by tariffs on equipment, not to mention a comment from the administration in March of 2025 that they wanted to scrap the whole thing. The U.S. is not alone in recognizing the strategic importance of the semiconductor industry to be competitive in the future. There are other CHIPS Act. In fact, the EU has its own CHIPS Act, and that is our discussion today. We're joined by Aida Kaloci to discuss how the EU CHIPS Act is the same as what we've learned about in the US, how it's different, and what it means for companies around the world that are in the semiconductor industry. Aida, thank you so much. Before we get into some of the details about the EU's implementation and what that means for companies, why don't you give an introduction to yourself?
Thanks so much for having me, Nathaniel. It's a great pleasure to be here and to discuss a very, very important topic. So I'm Aida Kaloci. I'm an associate at Cresco, a Belgian-based law firm where we focus on supporting entrepreneurs, startups, scale-ups, as well as more established companies and investors, including VCs, private equity funds, and corporates. I'm part of the intellectual property and ICT team, where we mainly work with clients in the tech industry, and that includes providing support on everything, starting from drafting and negotiating IP and tech agreements to advising on licensing, collaboration, AI, data protection, and open source issues. We also help clients with their IP strategy, whether it's for funding rounds, M&A due diligence, or resolving disputes. So lately, we're very lucky to work also with clients in the semiconductor industry. And of course, the EU CHIPS Act has definitely been a focus of our recent discussions. And as I said, I'm very, very happy to discuss this with you today.
Yeah, it's so nice to have you here and give us a perspective from Europe. I know myself, I've thought a fair amount about the US CHIPS Act, but it was not really until we set up this podcast that I was even aware that there was a European CHIPS Act. So can you tell me and our listeners, what are some of the differences between the US and the EU CHIPS Acts?
So let's say that we're a bit late, let's say, with adoption of the EU CHIPS Act in Europe. The US CHIPS Act was adopted in August 2022, whereas the EU CHIPS Act was adopted a year later, I would say. And the differences, that's a great question, because normally this really highlights the different policy approaches between the EU and the US. But before explaining the differences, I would like also to mention the common goal that both acts share, because they do have common goals. So, as you may know, the adoption of this act has been to some extent dictated from the COVID pandemic, where companies both in the US and in Europe were exposed to some weakness and shortages in the chip supply. And these shortages affected mostly the automotive and consumer electronic industries. To give you an example, it is said that in the US automotive industry lost production of millions of vehicles due to legacy chip shortages during and after 2020. And at the same time, in the EU, it is said that more than 50 billion euro were lost in 2021, which is basically the equivalent of 0.4% of the region's GDP in production, and that the calculation only refers to the automotive sector. So today, the shortages and vulnerabilities still remain, and the need to address these shortages, of course, becomes more urgent, especially taking into account the high dependency on chips fabricated in Taiwan, but also the potential disruptions if in case of an escalation of the conflict between China and Taiwan. So the similarities of both acts, so both acts share some common goals, and that is to reduce dependency on offshore semiconductor manufacturing, to enhance supply chain security and resilience, but also to develop domestic chip manufacturing capabilities. Now, going back to your question, what are the main differences between the US CHIPS Act and the EU CHIPS Act? As mentioned earlier, the difference lays in the policy approach. One aspect is the state aid and subsidy control. This is a big difference, and it relates to state aid and subsidies as regulated in the EU. So in the EU, state aid is normally every subsidy has to be cleared out by the European Commission under strict competition rules. So EU countries can only offer direct financial support if a company requesting such state aid meets certain expectations. On the other hand, the US has no such centralized restrictions, so states can independently offer incentives and state aid without a major restriction, so without federal approval. For instance, as far as we know, the US Department of Commerce has awarded Intel up to $7 billion in direct funding through the US CHIPS Act. So that's already quite a, let's say, a big difference between the US and the EU CHIPS Act. Another difference is the funding. So the amount of fundings under the US CHIPS Act is 52.7 billion funding made available to the industry, while the EU will mobilize 43 billion euro. So I stress the word mobilize because this is not direct funding. So the US CHIPS Act involves entirely new funding, whereas the EU CHIPS Act, on the other hand, is mostly basically reshuffling existing EU money. It is pulling it from older programs or current programs like Horizon Europe or Digital Europe. So definitely not fresh money out of the EU pockets. Another difference is tax incentives. The US CHIPS Act offers tax incentives to encourage investment and manufacturing. It's, if I'm not mistaken, up to 25% tax credits for investments, whereas the EU CHIPS Act does not provide any tax benefits. Even the funding structure and the process is different. So the US CHIPS Act promotes a relatively straightforward funding process when it comes to the funding structure and process. So companies just receive funding through the bilateral agreement with the US Department of Commerce, whereas the EU CHIPS Act is a bit more complex because companies must first secure support from member states of the EU and then obtain European Commission's approval under state aid rules. So the difference is already quite significant. Another difference is on the workforce. So there is a pledge under both the US CHIPS Act and the EU CHIPS Act to address the talent gap in the semiconductor industry. But while in the US, there's actual money on the table, there is a pledge of 200 million for the CHIPS for America Workforce and Education Fund. In the EU, there is a commitment to supporting talent and skilled workforce, but there is no dedicated funding on this point. Last but not least, the EU CHIPS Act introduced fast-tracking permitting for strategic projects, even allowing temporary derogations from environmental rules, which is quite a shift from the very tough EU environmental rules. The US has no equivalent mechanism, which means that it could potentially be more difficult for chip-making projects to address delays due to environmental reviews requirement under national legislation. So these are basically the main differences. As you can see, it's quite a different policy approach, and it remains to be seen how these differences will be implemented and how with this acts succeed in their common goal that they share.
You mentioned some of the funding that will be mobilized under the EU CHIPS Act. How much of that funding has been pledged so far, and where is it coming from?
So the headline figure for the EU CHIPS Act is, as I said, 43 billion euro. But of course, the number needs a bit of unpacking because roughly 3.3 billion comes directly from the EU budget under Horizon Europe and Digital Europe. These are already established programs that normally fund other strategies and programs in Europe. Could be digital, it could be energy, could be cybersecurity. So these are repurposed funds for research and development and capacity buildings. There has been some protest within the EU where the reshuffling or repurposing these funds has not been actually welcomed because it is seen as a way to take off some money from some important programs and repurpose it on a new strategy, on a new project of Europe, which is still uncertain, let's say. So 3.3 billion comes from already established programs, and the rest, so around 40 billions, is expected to come from member states and private sector contributions. So that includes normally national subsidies, co-investment, and also strategic partnerships. To give you an example, in February, the EU Commission approved a 227 million euro Austrian state aid measures to support AMS Osram in setting up a new wafer manufacturer facility in Premstetten. So the European Commission considered this as a first of a kind facility, and I will explain what the first kind facility is, and cleared the state aid. So yes, it's mostly repurposing, reshuffling some EU funds, and the most it will come from member states and the private sector.
So Ada, what have you seen related to implementation of the EU CHIPS Act?
So we're definitely seeing some progress in the implementation of the Act. Just recently in March, some member states, including Austria, Belgium, France, Germany, Italy, some other member states, issued a statement on the creation of the Semiconductor Coalition. That's basically a partnership which aims to reinforce cooperation and boost Europe's competitiveness in the semiconductor sector. So the main focus of this coalition will be to support research and innovation, to expand production capacity, and to develop a skilled workforce. In parallel, and that's a very important progress in the implementation of the Act, is the official inauguration of the CHIPS joint undertaking. That was a private partnership between the European Union, represented by the European Commission, participating member states, and key industrial associations in the semiconductor sector. So the mission of the CHIPS JU is to boost Europe's semiconductor autonomy by basically supporting research, developing cutting-edge design platforms, and building pilot lines to test and innovate in areas like mobility, health, energy, and robotics. So a big part of this project of this new establishment is also making these technologies accessible to European startup, small and medium enterprises, universities, but also large companies through a network of competence centers across the EU. And what are the competence centers? These are basically hubs of technical expertise that offer services such as access to design tools, pilot lines, trainings and skill developments, and general support for small and medium-sized enterprises and startups. So the CHIPS JU, it has an allocated budget. So a budget of 15.8 billion has been allocated to this partnership. Of course, most of the EU CHIPS funds will be channeled through the CHIPS joint undertaking. And we're already seeing, especially now in 2025, a lot of calls for proposals. And of course, there is an emphasis on building a skilled workforce and advanced design capabilities by offering these common platforms through these projects, calls for proposals. To give you an example, there is recently a call under Horizon JU Chips, which support startups and SMEs. And what it does, it's that it focuses on running an incubation acceleration program to support startups and SMEs involved in the chip design. Another milestone I would call it is the guidance that has been issued recently by the European Commission on the application process for first-of-a-kind facility. So what is a first-of-a-kind facility? A first-of-a-kind facility is a new and upgraded semiconductor manufacturing plant that brings innovation which is not yet available in the EU. So normally, these facilities can apply to the Commission to be recognized as either an integrated production facility or an open EU foundry. What is the benefit of being recognized as an integrated production facility or an open EU foundry? Well, the designation will basically allow them to be eligible for state aid under looser rules than usual. So once a company facility qualifies as a first-of-a-kind facility, it will be easier for them to somehow bypass or to obtain clearance from the European Commission and obtain state aid from member states. And that's, as I said, that's a big deal because it really reflects a major shift in the EU state aid policy. And that's, of course, justified by the strategic choices under the EU Chips Act. So yes, these are some of the implementation steps that we have seen so far relating to the EU Chips Act.
You mentioned just a moment ago about not only production facilities, but also integrated circuit designs as being part of that. So stepping back from the EU Chips Act for a moment, how are IC designs protected from an IP standpoint in the EU?
So in the EU, integrated circuits topographies are protected under a sui generis IP right. What does this mean? This means that it's a specific standalone form of protection, similar in some way to database rights. And normally in the EU, this protection is provided under the layout design of Semiconductor Products Directive, which has been implemented in all member states, of course. And what does this cover? So what does the layout design of semiconductor products protect? It covers the three-dimensional layout of semiconductor products. So not the function, but the physical design. So what are the criteria to receive protection? Well, to receive protection, the layout must be original, meaning it was created through the designer's own intellectual property effort. It must also be recorded or encoded in a way that it allows to be reproduced. And in addition, the layout must be registered within 2 years after it is first commercially used anywhere in the world. Well, if it meets this criteria, then the protection, and it's registered, the protection lasts for 10 years. As I said, the registration is generally required. So a layout design protection only covers, as I said, the visual structure, so not the functional aspects of the integrated circuits. Patents, on the other hand, protect the technical innovation within the integrated circuits or its manufacturing process, which of course offers a broader coverage. So patents are typically used in the EU to protect the manufacturing processes. So I would say the innovative techniques used to create integrated circuits. Think about methods for fabricating semiconductor components. Patents are also used to protect a new functionality. So if the integrated circuit involves a novel functionality or improvements, that can also be protected through patent. And patent can also be used to cover specific circuit designs or configuration that contribute to the functionality of integrated circuits. But patents have a very high threshold to reach protection. So normally, patentable technology needs to provide some proof of novelty and inventive steps. So patent protection is often quite difficult to obtain. And that's why a dedicated IP regime for semiconductor layout design was created in the first place in the EU. So normally patent protection is advisable only for truly innovative and an undisclosed IC development. There is, however, another way to protect integrated circuits, and that's also through trade secrets. So in many cases, companies in the integrated circuit sector also rely on trade secrets to safeguard proprietary processes, algorithms, or manufacturing techniques that provide a competitive advantage. So differently from patents, which require publications a trade secret normally can remain and should remain protected indefinitely as long as they are kept confidential. So the type of protection can cover a wide range of information, and that includes manufacturing techniques, design algorithms, specialized material compositions, and testing and quality control processes. So trade secret can definitely also be a good strategy to protect some certain aspects of the integrated circuits. Copyright and software can be relevant to protect integrated circuits. How? Well, that's especially when it relates to protecting software and design-related materials. So integrated circuits often rely on proprietary software or design-related documentation. So copyright protection can be used. We know that copyright protection, it's usually, when we think about it, we think about protection of artistic or literacy work, but actually it can be used also to safeguard software or other materials, like, as I said, like design-related materials. So that's definitely also a strategy to protect a certain aspect of the integrated circuits. And trademark protection should also not be underestimated. Normally, securing a trademark, it's important to safeguard a company's brand identity and prevent market confusion. So registering trademark, it's also necessary to protect companies, brand names, logos, or other identifiers from unauthorized use. And trademark, of course, requires a registration with the competent authorities. Last but not least, there are some other IP rights and protection that can be also used to protect integrated circuits, and that includes design rights. They could protect the aesthetic and ornamental aspects of a product, could be used to protect the visual appearance of a circuit or its housing, so the casing of the packaging of the chips. And database rights as well could be relevant because companies normally maintain a database of design schematics, layouts, and testing results. And this can be, under EU law at least, this can be protected if there is, in the event that the database shows that there is a substantial investment in obtaining, verifying, or structuring the content on the information into a database. So as you can see, there is a wide range of IP rights under the EU legislation that can definitely ensure a comprehensive protection of innovations in the integrated circuit sector.
So it was great to talk through all of those IP rights. And some of them are ones, of course, that I'm fairly familiar with, as they also exist in the US. Some of them seem more European specific, like the design rights and maybe this production layout right is fascinating. One of the things that you said earlier about the EU Chips Act in general is that there seem to be kind of specific focuses on trying to help startups and scale ups. What do you think is the best sort of suggestion for defensive strategies for these integrated circuit startups and scale-ups in the EU?
That's a great question. And one we actually get quite a bit from startups and scale-ups. So once a startup and scale-up covered the basics, so protecting their chip layout design, so registering the layout design, filing patents where possible, and making sure their software are properly protected and brands are also registered, there are some defensive moves a startup and scale-up can make. Well, first, think about publishing. If you have developed something but don't plan to patent it because you're a startup or a scale-up is not sure whether the new technology developed is patentable, a defensive publication can be actually a great defensive tool. So it creates prior art, which means no one else can come along and just patent the same thing later. And it's low cost and can really help avoid future patent disputes. Another strategy, so defensive strategy, is to conduct a freedom to operate analysis before bringing a product to the market. So what does this mean? This means that we'll need to conduct a startup, a scale-up will need to conduct a due diligence and identify whether there is any risk of infringing someone else's patent. So once you've conducted your due diligence, a startup and a scale-up may still have time to tweak the design or to look into licensing as well. Patent tools are also a good defensive strategy. So normally these are very, very interdependent. So joining a patent pool, a startup and scale up can get access to essential technology, but at the same time also reduce the risk of infringement claim. And finally, internal hygiene. That's a very important aspect that we're always stressing it to our clients. They need to put in place strong internal policies, NDAs, access control, and good trainings around trade secret management, because these are just as important as IP registration.
One of the other pieces of the EU Chips Act that you mentioned was trying to foster R&D, trying to bring all of that work back to Europe or to Europe for the first time, depending on what part of the industry we're talking about. Do you have any tips for how to structure collaboration with some of these R&D endeavors or R&D projects while still gaining some of the benefits of the EU Chips Act?
Yes. As mentioned earlier, the EU Chips Act offers semiconductor companies new opportunity to collaborate on research and development. Let's say entering into collaboration with the clear IP terms, it's quite critical, I would say. So first, what is important prior to entering into a collaboration agreement, companies should definitely review and document their IP portfolios. What does this mean? That they need to review and make a list of what is protected by patent, what is kept as a trade secret, and what potentially could be licensed. So in early stage collaboration, trade secret can offer flexibility, but patents might definitely provide for stronger protection against misappropriation. So it's crucial to have clear agreements on IP ownership and licensing. So these agreements should distinguish between background IP, so what each party brings on the table, and foreground IP, what is developed during the project, during the collaboration. The EU Chips Act does not actually mandate any joint ownership, but accessing funding or pilot line support may require sharing IP or granting access right. So this means that parties needs to have a clear view on what they are bringing, what their IP assets are, and how do they want to license it, what are actually the results they want to achieve from the collaboration, and carefully structure the content of the collaboration agreement. It is also very important to establish a very strong governance structure for the collaboration. So what does this mean? This means including a decision-making protocol, dispute resolution mechanism, and of course also agree on the roles to ensure the success of the collaboration. What is also very, very important, and we see it very often during our assistance and support that we provide to our clients, is that companies, partners should align on commercialization rights. So there is a need that each party can use and benefit from the results in its own field of use, while of course sharing the access to the IP assets where needed. Finally, the last important step is to pay attention to the funding conditions under the EU Chips Act. So EU funding often comes with specific requirements around dissemination and fair access, which need to be, of course, balanced with private IP strategies. And that means that, for instance, accessing competence centers or pilot lines may require special attention to access conditions, data confidentiality, IP sharing obligations. So as I said, collaboration through these facilities and through under the EU Chips Act can come with certain conditions, and that would involve also IP sharing. So making sure that this access rights, this licensing rights that are included in the collaboration agreement actually reflect your a startup or a scale-up strategy, but at the same time, it's drafted or parties agree to collaborate in a way that it's mutual beneficial, it's key. So yes, these are the strategies and these are the best practices that we would suggest to startups and scale-ups.
Ada, I have a surprise question for you. So this goes back to, I feel like one of the first questions we asked that I asked, right? What's the difference between the US and the European Chips Act? And you kind of walked through a bunch of things that You sort of said, well, the tax incentives might be better in the US, and maybe there's a more straightforward funding process, and maybe there's also more money just in general, or it's not modelized, it's new. So, not to sound rude here, but why would a company choose to go through the process in the EU rather than the US? What is Europe hoping to attract with this act?
Well, Europe's approach has always been so rather than a funding law, I would call it a regulatory framework for incentivizing the semiconductor industry. And that's quite keeping on the track of old tradition of Europe, where, of course, being a European Union, so a union of different member states, it needs to go through a lot of bureaucratic hustles, I would say, to implement such an important project, because it is an important project. And mobilizing such funds, of course, direct funding from non-federal country, let's say, or non-federal region, it's quite difficult. So what I personally think, it's quite I would say it's a call for action, of course, but it's a timid call for action because of its internal limitation. So that's already actually an initiative to be applauded, of course. But we'll see what the outcomes of both acts, which are now running in parallel, will be. It will be interesting. But again, it reflects the different policy approaches that have characterized the US policymaking and the EU policymaking in many sectors, not only the semiconductor industry.
Thank you for sharing the parallels and the differences as we walk through the act that doesn't make the news as much in the US currently, but has almost as large of an impact in terms of supply chain, even here in the United States, across industries and across products. So thank you so much for joining us for this podcast episode, and I hope we can have you on a future episode to talk about how the implementation is going.
Thank you very much. It will be my pleasure.
Thanks so much for listening to this episode of the Semi Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.